Good evening, listeners. Salam. And this is Dean Garrett from Liberty Law Solicitors on the Ask Your Lawyer show. And I've got Atiq Malik with me today. Hi,
Yeah,
Atiq.
it's everybody. Hi, good afternoon, good evening. It's Atiq Malik, Director of Liberty Law Solicitors. And yeah, I'm happy to be on here today. I think we thought, didn't we, Dean, that we need to have a full and frank discussion of employment law, where we are now, where we've come from, in terms of with this whole COVID-19 thing that's gone on and where we are today. What do you think, Dean? Is that the right topic for us to be discussing?
I think so, in particular in light of the announcement yesterday by Boris Johnson. There's been a lot of confusion up in the air.
Yeah, there hasn't there? I mean, everywhere I'm going, on social media, in the news, it's absolutely rampant. People are so confused. Have you seen some of the memes that are going up of Boris?
Yes, yeah, and my phone was littered with it yesterday on WhatsApp. It was, you know, not clear messaging given at all. But there's been a lot more of an update today from Parliament. And
The
from the
update that
announcement.
you're referring to, is that the update in terms of the document that's been published, which is called Our Plan to Rebuild the Government's COVID-19 Recovery Strategy?
That's it, and that came out today.
Yeah, brilliant.
Yeah, it's a roadmap that the government envisaged that we're going to be doing. And essentially there's step one is work itself. So it brings us nicely onto employment, the topic
Brilliant.
of where they see us.
If I can just go through that very quickly, the document. So for all our listeners out there, if you don't know what the document is, it might be a bit difficult to find sometimes on the internet. We do have a copy of it posted on our Liberty Law Facebook page. So feel free to go to our Facebook page, click the link, and it will take you straight to this document. Now, the document is called Our Plan to Rebuild the UK Government's COVID-19 Strategy, Recovery Strategy. And the first part of it starts off, when I'm reading it, it looks like it is word for word what the speech was last night that Boris did. So it looks like he was reading from this script. Would you agree with that, Dean?
100%. It's still ambiguity there. You know, the message isn't that clear at all.
And then after that, you've got a section which sets out, it's called the current situation. You've got a graph there setting out how things have panned out, a number of graphs and diagrams, and explaining how the transmission has taken place and how different parts of the country in terms of services such as the NHS, hospitals, etc. have been responding. And then further down on page 20, when I say page 25, I mean the numeric page, because on the PDF itself it's a different page number. But on the numbered page 25 of the document, they talk about the whole roadmap for work. So that's where we have the information, viewers and listeners. On page 25, the numbered page 25 of their plan to rebuild, we've got the beginnings of their roadmap as to how we are going to do this.
So on the roadmap then, if we look at what work is, you're quite right in what Boris Johnson said. It mirrors essentially what he says. For the foreseeable future, workers should continue to work from home rather than their normal physical workplace wherever possible. And that certainly itself, on the announcement on Sunday, caused a lot of confusion as to, for employees out there, whether they had to come back to work on Monday, today, for example. One of the notes that I've read is that this is a view taken that it should start from Wednesday this week.
That's right. It says that, it specifically says that this roadmap, these step-by-step processes for workers, employees, etc., is due to take effect from Wednesday of this week. And so today being the 11th, that would make it the 13th of May 2020.
And then, you know, following on from that, it goes that it should be minimized the number of social contacts across the country and keep transmission as low as possible. So they envisage that it's only for people who cannot attend work, and they're looking to minimize the risk of overcrowding on transport and in public areas.
So what I'll do then, shall I just read it out for people who haven't, are not familiar with this? So this is what the roadmap says. Work. For the foreseeable future, workers should continue to work from home rather than their normal physical workplace wherever possible. This will help minimize the number of social contacts across the country and therefore keep transmissions as low as possible. All those who work are contributing to taxes, help pay for healthcare. It just carries on there, just justifying why they're doing that. It then says all workers who cannot work from home should travel to work if their workplace is open. So I think that's a key point we need to come back to. What do you think, Dean, to just sort of analyse that? Sectors of the economy that are allowed to be open should be open. So again, I think we should come back and analyse that in more detail. For example, this includes food production, construction, manufacturing, logistics, distribution, and scientific research in laboratories. The only exceptions to this are workplaces such as hospitality and non-essential retail, which during this first step still remain closed. As soon as practicable, workplaces should follow the new COVID-19 secure guidelines as set out in the previous chapter. So in this document, the previous chapter, they have got the COVID-19 secure guidelines set out. So if you need to, we can always go into that as well and have a look at that. I think we should do that. What do you think, Dean? Go into that as well?
I think so.
Yeah. And then it says at the end, it remains the case that anyone who has symptoms, however mild, or is in a household where someone has symptoms, should not leave their house to go to work. Those people should self-isolate, as should those in their households. Yes?
Yes.
Okay. So, for the foreseeable future, workers should continue to work from home rather than the normal physical workplace wherever possible. So what do you think about that, Dean, then? What does that mean to you? For the foreseeable future, workers should continue to work from home rather than the normal physical workplace wherever possible.
Well, the position isn't going to change a huge amount. For those who have already been placed on furlough and those who haven't, we are already assuming that they're already working from home. So it's, you know, for a large amount of people, I don't envisage it changing unless employers take the view that they can reopen up and they're deemed to fall within the more essential food production, construction sectors.
Yeah, that's what, I mean, the way I see it is, I agree with that, Dean, and the way I see it is this: workers should continue to work from home rather than their normal physical workplace. So that part there is saying that as far as working practices are concerned, if you're already working, because you've got some people who aren't working at all, yes, who have just been furloughed, and so the message for them is different. But this is a message for those who have continued to work and have been working from home, and they should continue to do that, but where is possible. Now, where possible, I think it depends. That's open to interpretation, isn't it? What do you think, Dean? I mean,
huge amount of interpretation.
I mean, one way of interpreting where possible would mean in terms of infrastructure. Does the organization have the infrastructure to have people working from home or not? And infrastructure can mean technology and all the rest of it. But then I suppose the other side of it is also depends on how the company works. Because in some companies, whilst you may be able to work from home, it may not be feasible for the well-being of the company. What do you think about that?
Yes, you know, depending on the company itself, you know, and the infrastructure that they have on, for many out there, working from home it's been a new experience to them. So I can't see this changing a huge degree.
And then it says all workers who cannot work from home. So that's the second topic, I suppose. So you've got topic one, people who can work from home continue to do so where possible. But it's not saying that you can't go to work. It's just a recommendation that they say you should continue. And then it says all workers who cannot work from home should travel to work if their workplace is open. So this is now positive encouragement, isn't it? It's essentially, you know, go back to work.
Yes, and but you know, it raises again the issue of transport. And the next line on from that is minimizing the risk of overcrowding on transport and in the public places. Certainly on the previous, yesterday's radio shows, listening to them, there is a huge concern out there, particularly on the buses, for example. How do you maintain that? So the government have, in the previous chapter, which we could come on to, talked about shift staggering, so that we can try and filter in how many workers coming into work, try and mitigate against that.
I suppose it also depends on where you work and how you work, isn't it? I mean, in a place like London, you're not going to have many workers living in the city of London, are you?
No.
Okay, yes, a lot of them might be working from home, but there might be a situation where some of them cannot for various reasons, depending on their work. And people, it's almost a norm now. People commute to work great distances across London on the Underground, across the country on trains. So what happens to those people who cannot get to work and cannot work from home? I mean, it's a very difficult situation. At the moment, the problem's fine, because at the moment, those people can still be furloughed. But I'm thinking this is leading up to a situation where the furlough grant that's being paid is going to be reduced and in due course taken away. And when we get to that stage, if a business cannot afford to pay a worker's salary because they cannot get to work, and persons are not at work because of this issue with transport, then the situation would be dire, wouldn't it, in terms of both the business and the employee? The employee would be at risk of redundancies, and the business could be at risk of collapse because they can't get any workers in.
Yes, and there doesn't seem to be much harmony between, what the Department for Transport is saying on how they will, assist workers in this regard.
And then what you've got there, that leads us into another subtopic. We've got legislation which has been thrown about on social media that I've seen, a particular Section 44 of the Employment Rights Act. What I think we should do, if you can just, Dean, if we do it like this, if you just read out what Section 44 says, as in verbatim, I will then put that into context and take the viewers and listeners through what that means in real life.
Yeah, I will do. Just give me 2 seconds. I do apologise. So Section 44 of the Employment Rights Act, verbatim, says, an employee has the right not to be subjected to any detriment by any act or any deliberate failure to act by his employer, done on the ground that, having been designated by the employer to carry out activities in connection with preventing or reducing risks to health and safety at work, the employee carried out any such activities. B, being a representative or worker on matters of health and safety at work or members of a safety committee in accordance with arrangements established under virtue by virtue of any enactment or by reason of being acknowledged by such by the employer. And do you want me to read out the remaining?
Yes, please, yeah.
2, for the purposes of the subsections, whether steps which an employee took were appropriate is to be judged by reference to all the circumstances, including in particular his knowledge and facilities and advice available to him at the time. An employee is not to be regarded as having been subjected to any detriment on the grounds specified in subsection 1E, which is in the circumstances of danger which the employer reasonably believed to be serious and imminent, he took or proposed to take appropriate steps to protect himself or other person from the danger. If the employer shows that it was or would have been so for the negligent for the employee to take the steps which he did take, that a reasonable employer might have treated him as the employer did. So
this legislation is what people are doing is they've screenshotted this and they are sharing this all over social media. And what they are suggesting is, well, if my employer or your employer forces you to come to work and you refuse to because of your concern for health and safety because of COVID, and as a consequence of that, you are punished by employers in terms of salary deductions or losing your job, then that is a detriment under this act, and you can bring a claim against your employer. In a nutshell, I think that's what the message out there is at the moment, that people are understanding it to be. Is that how you understand it as well, Dean, that social media is sort of pushing that out?
Yes, and you know, it's one of the rare occasions for an employment lawyer to now look at health and safety and advise employers on health and safety. What's interesting about the legislation is it comes down to the employee's reasonable belief that, you know, there's serious and imminent danger to them. So, you know, it's not in the belief of the employer, it's whether an employee believes there's to be serious and imminent danger, which is a nuance there, which is, you know, which gives a huge advantage to employees if they are going to raise this.
Yeah. Now, what I want to bring to everyone's attention is it's not as straightforward as that either, because in employment law, employers have a duty to employees. Similarly, employees have a duty to employers. So some of the key rights, for example, that an employee is entitled to, which is particularly relevant in the current situation, is to be equipped, for example, with necessary safety equipment to do their work. Now, one example of that then could be PPE, personal protective equipment. In COVID-19, we are hearing everywhere recommendations for masks, gloves to be worn, etc. However, nothing compulsory in that aspect has been stated by government. I mean, if we go back for just a second and look at the document that we were referring to before, and that document referred to secure guidelines, yeah? And the secure guidelines, which is on page 22, with a numbered page 22 of that document, sets out information to help people understand. But to be honest with you, it's very brief. There's nothing in there that says it's compulsory to provide for employees to wear masks or gloves. So again, it has to be dealt with, I think, on a case-to-case basis. And if an employee it's going to be a big question whether or not an employee who refuses to come to work because they haven't been given masks or gloves and is then made redundant or suffers losses in salary, whether or not that person can bring a claim. I think what it would come down to is an examination would have to be conducted of the whole workplace as a whole, really, isn't it? How much in contact are with other people? So, for example, someone's coming in and is sitting in an office all day. They've got no contact with members of the public, no contact or very limited contact with anybody else within their own workforce. Then there's an argument there with what necessity is there for masks or gloves. And so that's one aspect there. I mean, another right that an employee has is to be able to inform their employer of health and safety concerns that they have without fear of any disciplinary action. And I think this ties into Section 44, but it also ties in to the general exception, doesn't it, Dean? Because to bring a claim for ordinary unfair dismissal, you normally have to have a 2 years length of service, yes? Now, if this is a legal right, but you have a legal right to report health and safety concerns, and then similarly, you have a legal right not to suffer a detriment. And then as a consequence of that, you are dismissed and you haven't been there for 2 years. I would say that that person still has the ability potentially to bring a claim for unfair dismissal on the basis that they were dismissed for asserting a statutory right. What do you think, Dean?
Certainly, yeah, it would fall within one of the automatic unfair reasons that you certainly could bring a case on.
Excellent. So, just going on, examining this, I mean, the employee also has responsibilities, and that includes informing the employer of any change of circumstances, in their circumstances, in their ability to do the work. And they also have and responsibility to take care of their own health and report any issues of medication, etc., to their employer. And I think that's quite important, because if that isn't done and they suffer some sort of harm, then it's difficult for the employer to be held accountable, because the employee hasn't satisfied their own duty of informing the employer. And the employee also has a responsibility not to put themselves or anyone else at risk, and also to cooperate where possible with the employer in taking part in regular training or health and safety procedures. So what that would mean is, let's say there's a business and they require employees to follow a certain protocol in respect of COVID-19, for example, and certain employees do not, then that it could be an act of misconduct on basis of which that employee could be sanctioned in terms of warnings or dismissal. What do you think?
Yes, it certainly could fall under that. You know,
Well,
it does that. Reading this and the guidance itself, it doesn't really take into a lot of practical considerations, particularly on like PPE, the shortages that we have out there.
yeah.
And I think your point earlier about, you know, looking at it from an overview of the whole picture before we could assess whether a claim would be there. You know, the tribunals, if a case ever did go that far, would have to really look at what efforts an employer did, you know, and I think it will be a consideration on the lack of PPE out there and the availability. What I have noticed is from the guidance that they've published, ACAS have updated their website and they've gone into a lot more detail, but certainly it's not a mandatory requirement. Again, they're saying it's only good practice.
But also, another point, if you look at legislation section 44, what it says, why it does say that what the employee believed, there is that word in there that's been inserted between the word employee and believed, the word reasonably.
Mm-hmm.
So that's the test. Because if an employer has a belief that they're in imminent danger, they have to demonstrate that that is a reasonable belief to have. And so if they are found to have an unreasonable belief, then that would be defeated, wouldn't it? Their complaint.
You would.
Under that part of it.
Yes.
Now we're coming to the end of the first part of the show. So viewers, listeners, stay with us and we'll see you on the other side. If you Ask Your Lawyer show, I am a guest on the show today, Atiq Malik, Director of Liberty Law Solicitors, and your host, in actual fact, is Dean Garrett. Dean, over to you.
Thanks for introducing me, Atiq. Appreciate it. So, listeners, just before the break, we were talking about the new guidance issued by the government, the plan to rebuild. It was aptly named, and on our Facebook page, Liberty Law Facebook page, you'll be able to download that guidebook. And on page 25, you'll see on the earlier show we were just going through and breaking it down. And then the question of Section 44 of the Employment Rights Act came up, because this has been a topic that's, you know, been put all across social media, particularly today. And as a recap, it talks about health and safety and the employer's duties to an employee in not suffering a detriment in having to return back to work. And the test we were exploring was what that impact may be, and we were speaking about how employees would have to reasonably believe that they were in either serious or imminent danger and in refusing to return back to work. So that's where we were. And to follow it on, I thought what might be good to talk about, Atiq, is what are some of the good practices that an employer could do or an employee should request from the employer to avoid any imminent serious danger. And what we have noticed is that the guidelines themselves aren't very detailed, but I alluded to before the break that ACAS have actually updated their guidance, and they've listed quite a comprehensive list of good practices. So if I can just read out a few of those, and you know, they're quite good, but with them comes practical considerations, and certainly a question in respect of discrimination I wanted to speak to you about, Atiq. So ACAS says, you know, to ensure social distancing if they come into the workplace. I suppose, you know, if you're working in small offices and premises themselves, or even hot desking, which has been quite a feature amongst, you know, companies and employers out there, that's got to end now, wouldn't you say, Atiq?
Hot desking, why do you say it needs to end?
Well, if we're to keep social distancing and not using the same tools and facilities, so the same computers, certainly that would be against a good practice here, you would argue.
Yeah, see, this is the thing.
Would you agree?
This is the thing. It's so open to interpretation, and this is what I would play devil's advocate and say, from a business perspective, it all depends on how the business works. Because for some businesses, hot desking is the only practical, feasible way for them to run. They may not have the finances to have separate offices for everybody, and so let's look at it like this. What Section 44 says, which is what's been banning about on social media, is the danger has to be reasonably believed. Yeah, it has to be a reasonably held belief of potential danger, and has to be imminent danger as well as serious danger. Now, it's hard to measure with COVID, I'd say, whether it is imminent danger or not. Some would say yes, it is, because it's rampant right now. Some may say, well, it's not imminent because some people might not actually develop symptoms at all or for quite a long while. But then similarly, with hot desking, for example, if there was a practice in place where after using your equipment for the day, you wiped it all down, or the business had cleaners coming in at the end of each day, which were disinfected all the workstations. And so the next day when you come in, it doesn't matter where you're sitting, it's all been cleaned and disinfected. Would that not be sufficient?
Certainly, I would probably say, certainly in the deep cleaning part and showing that there's processes in place, you would mitigate against that. Certainly that would be a good thing. Yeah, I would agree with that. ACAS have gone on to say, be especially careful and take extra steps for vulnerable groups, including those who are pregnant, age 70 or over, or who have a long-term health condition. So on this point, you know, we spoke about before shielding, and the government did rightly say that those employees who needed to be shielded could be placed on furlough, whether there is work or not. We've seen the shielding, we've seen furlough coming to an end, or likely to come to an end in some measure. This is going to be a big concern for this sort of grouping. Wouldn't you agree?
Yeah.
Because how are these people going to be, you know, if you have a long-term health condition, how are you going to mitigate against those risks? And certainly ACAS points to that a risk assessment has to be carried out.
Right.
So for an employer, they'll have to look at, and I think for employers that it will be key that they keep a work log and show that they have actually looked at what risks and whether they can avert those risks, and that they've looked at all options available to them. Because the caveat here will be, you know, to not do these risk assessments or to distinguish these employees, it could amount to discrimination.
Yeah,
which is another factor.
It's another factor. I'm really glad you brought that up, Dean, because have you noticed in the public arena, in terms of all the commentary that's flying around, social media posts, etc., nobody's picked up on discrimination yet. And in my opinion, it's only a matter of time before people with medical conditions start making requests for reasonable adjustments. Those reasonable adjustments are not complied with, and then you have claims for that, for failure to make reasonable adjustments. Or taking it one step further, somebody makes a request for reasonable adjustments, it's refused, and not only is it refused, because the person refuses to come to work, they are then dismissed. You then have a potential claim of unfair dismissal and disability discrimination. Now, this is something nobody, I think, has picked up on so far, and it's only a matter of time before I think it explodes. I mean, what do you think about that, Dean?
No, I completely agree, and this is why I think for employers out there, they'll need to demonstrate this, and they will need these risk assessments. They will need to demonstrate that there has been no unfair treatment. So it's not something that employers who wish to get workers straight back in can rush. I think that it is going to take time.
That's right. And then going back to Section 44 then, I think employees, it's a double-edged sword, I think. I think it's important for employers and employees to know that putting aside disability and redundancies and the unfair dismissal claims, there's additional protection for anybody who's genuinely concerned about health and safety. And because of that, and due to ACAS guidance too, employers should be actively engaging and ensuring all health and safety protocols are followed and employees are not put at risk. But similarly, employees should be cautious about thinking, oh look, Section 44 means I don't have to go back to work. And if I don't go back to work and they don't pay me, which is a detriment, or they don't keep my job for me and I suffer a detriment because I'm dismissed, I've got a case against them. I think these are such unique circumstances that a tribunal will not take a simplistic look like that. They will take a more likely a holistic view of all processes. And if there was a situation where the business was able to accommodate reasonable health and safety protocols, and it was a situation where the people were required to come back to work, then it would be very difficult, I think, for an employee to simply say, oh, look, they may be redundant, Section 44 applies. What do you think?
Yeah, yes, I completely say so. And I think, you know, as providing they can demonstrate that they've done the relevant training for, you know, employers out there, they've tried the best to put facilities in place, such as hand sanitizers, tissues, tried to implement social distancing. I think all these, you know, a tribunal will rightly take a holistic view to it. You're correct, I think.
I mean, let's say, for example, at the moment, this is a situation, furlough grants are paying 80% of workers' salaries. So employees across the country were given the option, you either take the 80% pay home, so 20% cut, and don't come to work, or you don't accept this variation to your contracts and we terminate employment. Now, at that point, a lot of people, you know, opted for taking the grants and taking the 80% furlough wage. And if people did not do that, they may have been subject to redundancy, but I haven't heard anything on the grapevine of that actually happening. What happens now if the government says, okay, we're now going to reduce the furlough grant to 40%? 80% wasn't too bad because people might be losing a bit of the salary, but they're saving on commuting costs and they're not having to do any work. When you enter the realm of 40%, what's your opinion, Dean? What do you think could trigger? What do you think could happen next?
Well, certainly on that side, we're going to then see employees whether they're going to accept that, because the guidance out there is that the employer should notify them.
Yeah.
So if that comes, we're going to at that point see whether employees are going to accept that 40%. For, you know, and for many, they won't be able to do that, and that will give rise to where does an employer take it forward from there.
Yeah.
If an employee doesn't agree to it, it's going to be, you know, what are the options left? Because most contracts don't contain layoff provisions, or if they did, an employer probably may be looking into that. But for the majority out there, layoff provisions aren't there. So you would certainly, it's going to be a big mess, you know, on how an employer would take that forward if an employee rejects it.
Well, let's work through that. So 40% is offered to an employee. Employees are told, look, I can't keep you off work now. I need you to come back to work, and you can't work from home. You need to work from the office or the workplace. It's either that or you stay off at home on 40% wage on furlough. Now, if that happens, does an employee then say that my employer hasn't given me a choice and I don't want to come to work, and because I refused, I was placed on furlough and lost 60% of my wages, irrespective of what the contract says? Is that an argument there? And then similarly, if the person is told you either accept a 40% furlough or you're made redundant. So let's put aside come back to work. You're made redundant. They refuse to accept 40%. They're made redundant. Then they say, oh, look, I've got a detriment now. I've lost my job because I wouldn't accept the furlough. Now, that I think is slightly different because that's not health and safety, is it? Section 44 is not engaged there. because you're not
No.
being given the option to come to work. You're simply told this is another variation or that. So I think in that situation, if a genuine business needs, a redundancy situation does arise and a person can be terminated, I think. In that situation, Section 44 doesn't engage about health and safety detriment. The first situation, if a person is told, look, you either come to work or you stay on furlough, or you either come to work and you're dismissed, could Section 44 be engaged at that point?
Yes, but again, I think it's what we were addressing before, that reasonable belief. If you were to refuse as an employee to return back to work upon the request of your employer, you would need some reason as to why you couldn't return back. And you couldn't just take that gut approach, that approach without actually asking your employers what safety measures they have done, certainly, before returning back, because otherwise there is no reasonable belief that you're in imminent danger.
So what I think that does, I think that breaks it down into three categories of employees, workers, etc. Category one is someone who's completely fit, has got no medical underlying issues, and neither does any member of the household. Nobody's at risk, nobody's vulnerable. They simply just don't want to come back to work. I think that person will be in difficulty unless they can show that the workplace, the way the workplace is arranged and works, is so awful and such a danger to health and safety that they just simply cannot come back. And I don't think most employers will be able to demonstrate that, because most employers can take because the social distancing measures, they're not very difficult to impose either, depending on, I suppose, the dynamics of the workplace. But you could have staggered shifts, you could have, like I said, deep cleans every evening, you could have people working, one person from each office so they don't cross paths, all sorts of stuff. So and no contact with the public at all. I think these sorts of measures work. I think the difficulty then arises for businesses is the next two categories. One, where a person themselves has medical issues which could amount to disability. Now, a lot of people do not understand what disability is. Please forget, listeners, viewers, please forget what the local council tells you is a disability. Ignore them. Just because you haven't got a blue badge does not mean you're not disabled. Disability means if you suffer a medical condition which affects you on a daily basis and on a long-term basis, and that long-term basis could be a continuous long-term basis, or it could be an intermittent long-term basis where it comes and goes. So believe it or not, if you have severe debilitating migraines, even that potentially could be argued as a disability under the Equality Act 2010. And most people would not consider migraines to be a disability. So this is where specialist advice from an employment law specialist really is worth its weight in gold, because you might have rights which you're not aware of unless you get the right advice. Now, so a person has a disability, the ball game changes, because now what they're doing is making requests for reasonable adjustment under the Equality Act, saying that I can't come back to work because of this, okay, and therefore don't dismiss me or don't sanction my wage. I mean, that's a bit of a difficult one, isn't it? I mean, how does that work? Don't dismiss me. So they're disabled. They are told we're going to furlough you.
Yeah, and it's going to be at the reduced, let's say, on the reduced rate of 40%.
But are they receiving unfavourable treatment there?
Well, certainly if they are able to bring back the majority of employees back into the workplace, but they haven't carried out risk assessments, or they haven't looked at what adjustments they could make, then you could say it's unfavourable treatment, that the employee has been forced back into this position where they cannot return.
Well, I suppose that brings us back to word, isn't it? It's the word reasonable adjustment. So is that adjustment, that request, in the circumstances reasonable? I think that's what it comes down to. Just because a disabled person has made a request doesn't automatically mean it has to be granted. So that's where an examination will take place as to, in the circumstances, is that request that they're making reasonable? So I suppose the flip side of it is, if someone says, I don't want to come back to work, please furlough me, and there's a furlough grant, and the employer refuses to furlough, and require them to either come to work or be dismissed, I think in that situation, that person could have a claim for reasonable adjustments.
Yes, I think so too.
Yeah. And then the last one, think about this one, Dean. I haven't heard anybody else mention this yet, but I think there's a potential claim here. You're completely fit, no medical conditions, but you have somebody in your family who does. Discrimination by association. What do you think, Dean? Do you want to explain that quickly, what discrimination by association is to the listeners? And then let's have a think about that.
So under the Equality Act, if discrimination by association is if you've received unfavourable treatment or less favourable treatment because you're not because of what you may have, a protected characteristic that you may have, so disability in this instance, but because of someone a family member. So let's say, for example, at home, one of my relatives who I live with is unwell. I'm asked to come into work, but there's unsafe practices going into work. While the risk may not be to myself, I'm unable to do that because of my family member who is unwell. So certainly you could argue that I'm receiving less favourable treatment because the reasonable adjustments haven't been done because I'm associated to a relative who is disabled or has a protected characteristic.
Yeah, and so from the example that I've given, so let's work this through. Somebody has got a vulnerable family member and they're being told, come back to work. The employee says, look, I'll take the 40% furlough because I'll get a grant, because otherwise if you're just shielding, what do you get? Sick pay, SSP, which is about £90 a week.
That's it.
So you're better off being furloughed even at 40%, 80% currently, or 40% if it comes down to that in the near future. That's still a better position to be in if you want to protect your vulnerable family members in your household, as opposed to being on SSP or coming to work. So to make that request, the request is refused, they're dismissed, or not paid at all. They said, well, now your leave is unpaid leave, for example. Then can they bring a case of discrimination by association on that point?
Yes, I would say that there are grounds there. Certainly, and for an employer to take the view that they don't have to factor in this. Certainly it could be discrimination by association from how you've laid out that scenario.
And I've got another scenario for you, Dean. We've covered all of these different types of discrimination. I would put these under the heading of the direct forms of discrimination. I know direct discrimination is a category in itself, but if we just sort of lump it together and say these are direct forms against individual people. But then if the company has a PCP, practice criteria or provision in place, policy in place, practice criteria policy in place which puts certain workers at a disadvantage. And in this case, it will be workers who are disabled or have relatives that are disabled. Would you say not be, if they don't make any allowance for those sorts of people, is there not a risk there of indirect discrimination claims being brought as well?
Yes, again, because while the policy may not look on the face of it discriminatory, there it is targeting an individual group here, and that group being family members of employees who have a health condition or long-standing health condition or concern and should be shielded. So yes, so for a lot of employers out there, even that introducing such policies will have to be carefully looked at.
So I think the way forward has to be that nobody, employer or employee, does any sort of a knee-jerk reaction, and both sides look at each individual situation from a holistic perspective, taking into account the full circumstances of the business, how it works, its needs and requirements. And of course, there's a difference, isn't there, Dean, with ordinary people that have been told to go back to work and what we know as key workers.
Yes. For key workers themselves, well, really, for key workers, that position hasn't changed at all.
Yeah.
And they're carrying on working. So really, you don't envisage much changing on that aspect.
So if a key worker is told to go back to work by the employer, like I said, their position is the same as it was pre-COVID, really, unless they can argue a genuine health and safety concern because of an underlying medical condition, I would say, or due to family household member who is vulnerable and at risk. So looking forward then, what are best practices? I would say whatever agreement employees come to on how to move forward, it has to be in writing. It really does. I know there's been contradictory guidance from HMRC and the government themselves as to what is required. Some are saying there needs to be a contract in place. Some are saying this needs to be in writing. I would prefer there's a contract in place, but at the very least there should be something in writing, because believe it or not, Dean, on social media, I've had people contact me and have said that their employers have not given them anything in writing, not even an email, and they genuinely believe there's no necessity or requirement to do so. So I think whatever is agreed to protect the business and the employees has to be in writing in some shape or form. I think there has to be risk assessments, regular risk assessments carried out, and processes put in place that protect the employees and in turn protects the employers. And in that way, if an employee is told to come back to work, for example, and they refuse to, then the employer has something to back them up. Now we're running out of time, but very quickly, Dean, what do you think the position is then for people who say, well, how can I get to work by avoiding public transport? This whole conundrum I started with the guidance.
For that, employees need to look at staggering shifts. That's one answer, practical solution that can be taken. And they need to look at themselves, whether there can be, a form of, because one would assume car sharing wouldn't really be suitable either, because it's confined.
Yeah, social distancing and all the rest of it, yeah.
Does the employer have sufficient car parking facilities? In central London, you're going to probably say no, driving isn't. So there really has to be a degree of flexibility, and also take a view as can it not be a one-off situation? Can an employee not work from home? I know that comes with financial implications, but certainly if an employer can demonstrate that out, that they've considered all options, that would be the safest option. And again, put those options in writing.
Brilliant. I think what I would say, because I think we've come to the end of the show now, and what I would say is that, number one, I know for a fact within the next 24 to 48 hours, the government's going to publish some more guidance, just like we have done previously. We had 3 different versions of guidance for furlough when it was first released. The government in this document, which is available from our Facebook page, has already said that they are going to be releasing further guidance, so watch out for that. But on top of all of that, I think there is very much further room for discussion here. I think if anybody needs further clarification or wants to discuss this, come onto our Facebook page. Let's have a discussion about it on there. We'll signpost you to whatever information we think is helpful to you, or contact us directly by email or phone. And that's it. We are at the end of the show. Thank you, listeners. Dean, do you want to finish off? Sign out?
Thank you, listeners, and hopefully we'll be on again shortly to give you another update on employment law.
Thank you. Thanks, guys.
Goodbye.
Stay safe.